Welcome back to Canadian Justice, where we are discussing a case involving Dr. Jordan Peterson and the principles of freedom of expression. Now, George, in this case, the regulator, the College of Psychologists, has imposed this re-education order on Dr. Peterson. But if there is no clear connection between the speech and the profession, and in this case, we know that the speech had really nothing to do with the practice of psychology, how does a regulator find that they have jurisdiction to make an order like this?
Yeah, so let's start with what a regulator's mandate is usually, which is governed by statute and meant to protect the public interest. So clearly we have accepted as a society, and most of these organizations are self-regulated through statute to protect the public interest. What we have here is the College of Psychologists of Ontario that have a code of ethics that force their members, and yeah, I can say force their members to comply with those code of ethics, one of which is to ensure that what they do, even when they're not practicing as psychologists, is not to undermine public trust in the profession. So those controversial tweets that Joanna referenced have been found by the college could, let me underscore, could undermine the public trust in the profession. And that's where they get the jurisdictional hook to be able to sort of go through their remedial process.
But is that enough? Is that enough for them to actually have the jurisdiction, George, to say this conduct has now brought the profession into disrepute or has damaged the profession?
Yeah, there's a whole series of cases and whatnot on off-duty conduct, and they're all over the map. The divisional court's hearing this case on June 21st. The standard here of review, which is important, is a reasonableness standard. Did the regulator here apply this reasonably? From my perspective, and when you read the decision, all they do is state the value of freedom of expression, but they do not go through the analysis that the Supreme Court of Canada has dictated we must do through Dore, Loyola, and Trinity Western to give full effect, and that's the language, full effect to the charter right that is being exercised.
Yeah, because this is a fundamental right here that we're talking about, and the court and the regulator need to give full weight to that. Joanna, is there anything you want to add to that?
Yeah, just that Dore is very clear that where you have a charter right, and particularly freedom of expression is a very strong right, where pretty much it's protected as long as the expression doesn't tip over into something that's tantamount to violence, right? It's a right that animates all other rights. And so just saying we note the importance of freedom of expression clearly isn't going to cut it here.
And, George, in this case, as we said, we're dealing with speech. It's a charter protected right. And doesn't matter what profession someone is in, whether it's, in this case, it's a psychologist, but this could also apply to a lawyer, an accountant, if they are saying something that is unpopular. And are you saying that there's a higher bar for a regulator to find that speech alone, which is a charter protected right, can be worthy of sanction by a professional regulator?
Yeah, let me start by saying relying on concepts of undermining the public trust when it becomes to freedom of expression, in my view, is very dangerous, because those values, those norms change over time. And I think I'm a very, free speech hawk when it comes to this. And when you are starting to apply subjective factors about undermining public trust, when? 10 years ago, 5 years ago, now, 5 years from now, it's too malleable. I think we still need to give full effect to that charter protected right. Yeah, there are other cases. Dore wrote a stinging letter to a judge, scathing the judge for, how he treated him in court. And that crossed the line. That was freedom of expression, but we have some direct link there to the profession, right? To the what is expected of officers of the court when they are in court, and even after they leave the courtroom. Right. So there could be context for sure where freedom of expression doesn't carry the full weight. But I think Dr. Peterson's case and the case in Dore are polar opposites and the linkage to each profession.
We've got to go to commercial break now, but when we come back, I want to talk about some of these other cases that the Canadian Constitution Foundation and George, you have outlined in the argument that we're going to be making at this intervention about other professions and how that issue has been considered there. We'll be right back.